Good morning, and thank you very much for joining us. I am Yori Folarin. My name is Yori Folarin. Let's look at, settling down to work again. Let's look at the Electoral Act, the 2022 Electoral Act, and indeed how it juxtaposes with the 2023 general election. Well, our guest for that is a lawyer, former Attorney General of his Osun State, and he's a senator, well, former senator. He's not returning, but Senator Ajibola Bashiru, when he was there, was the spokesman of the Senate. A fine morning to you, Senator Ajibola Bashiru.
Yori, good morning. I'm still a senator. Our cutoff date is June 11, so don't send me away from the Senate prematurely.
My
yes,
bad.
I'm not returning back as a senator, but
My
I'm
bad.
still a senator for life. But
Once a senator,
a current senator, I'm the
you will be called senator
until June 11.
That's right, sir. My bad.
So it's too early to send me away.
Okay, then. Okay, so you're very welcome, and thank you for making space for us. There's been a whole lot of conversation and talk. The actuality of the Electoral Act is what it is, the 2023 Electoral Act. And then we have just finished with the, it's still one or two things to be done, but the 2023 general election. Now, let's talk about that, because there seems to be much ado about it. Yesterday, I was listening to Dele Alake of the Presidential Campaign Council, and at a press conference, he was putting out that, look, maybe people don't understand it. So let me ask you. One of the things that was said there was that there is nothing in the Electoral Act that compels INEC to broadcast results. So clarify that area for me, please, as a lawyer.
Yeah, I think it's very important to separate, fact, from fiction, and they also separate emotion, insinuation. The law as it is today on electoral system in Nigeria is what is contained in the Electoral Act 2022, and it has made some profound provisions to guide our election. But of course, just like any piece of legislation, there are always room for either genuine or mischievous interpretations of provisions of such law. But at the risk of sounding immodest, some of us are in a advantageous position to speak on the Electoral Act. For purpose of record, I was a member of the Harmonization Committee of the Senate, and I am the sole representative of the Southwest on that committee to harmonize the gray areas in the Electoral Act 2022. that battered that very important piece of legislation. So at the risk of saying that I'm appealing to authority, I will say that one has a very good grasp of what are the provisions of that Electoral Act and what are also the underpinning philosophy of some of the provisions on the Electoral Act. I will start by answering your question, having set this tone on the question of so much ado, if I will use your word, on the electronic transmission of results. Yori, you will recollect, I think it's good to set the law as it is and avoid certain words that is not even the Electoral Act. The provision relevant here is Section 60 of the Electoral Act 2022. Section 60, subsection 4 of the Electoral Act now provides that after result might have been announced, result recorded on the electoral forms at the polling unit, and the actual scores of the parties already announced. Section 60, subsection 4 provides that the presiding officer shall voters and results of election in a manner as may be prescribed by the Commission. That is the actual word used in Section 60, subsection 4. That is, the word transfer was used and not the word transmission. And the word transmission was deliberately are substituted for transfer when the final draft of Electoral Act is being done, because there was of a network coverage and, of course, security of network coverage. So what that presupposes that once election is concluded at every polling unit, it's expected that everybody, including party agents, will know the results of everybody that participated in that election. And what is expected of the presiding officer is to transfer it in a manner provided by INEC regulation. So to the extent that a presiding officer has used the beavers, now using the what the technology used in the 2020 election result, to the extent that it has been transferred, there has been compliance with that provision of section 60 subsection 4. But then section 64 subsection 6 provide for utility or possible use of materials and the result transfer from the respective polling unit. And that will be in the context where there is a dispute at the level of collation of result. It's expected that when there's a dispute as to collation of result, in order to ascertain what was the proper result that has been transmitted, the collation officer may have recourse to what has been transferred by the presiding officers. Contrary, what we see in reality and what is being bandied around by many people, I'm saying that the context in which Mr. Alake is speaking is that there's no need to confuse Nigerian people as to what has been provided for in the Electoral Act. There's nothing that says that a result must be uploaded on IRF before the eventual winner is declared in the election. In reality, the Electoral Act provides for manual collation of election results in case there is dispute in that regard. I think that is my take on the issue of controversy on whether election results ought not to have been, and winner ought not to have been declared before election result is announced.
Okay, because as you know, one of the areas that is up in the air is you saw all sorts of letters of petitions circulating, not just here within the ambits of the law, but even those going out. People are saying that INEC didn't obey its own rules. What would be your commentary on that assertion?
Face my response by referring to the danger that Professor Woloyin Soyinka pointed out, and that is an attempt to scandalize and intimidate the Nigerian judiciary. When parties have submitted disputes to court, in which case I believe the two other leading presidential candidates, Mr. Peter Obi of the Labour Party and Alhaji Atiku Abubakar of the PDP, have submitted their petition, and this is already before the court. But one find it strange when even a first presidential candidate is going to directly attack, and seeming to suggest impropriety on judiciary. I think this is dangerous for a democratic institution. Then, as to those writer, it's unfortunate that somebody who is known in literary world, Chimamanda Adichie, who put pen to paper what, with respect, I regard as fiction. One, to say that election results were manipulated because they were not transmitted, show that she has not availed herself a copy of the Electoral Act to read before putting pen to paper. Then to also making allusion to the fact that opinion poll before the election suggested that our candidate, Mr. Peter Obi, would win the election. Also, it cannot be a basis to attack the democratic credential of the election. In any event, even internationally, United States, there have been many opinion polls that suggested some candidates will win, and eventually those candidates will not win. Would that undermine the democratic credentials of those elections? Another aspect of it has to do with the sovereignty of the Nigerian people. I think we should refrain for what I call colonial mentality, appealing to colonial powers to seek to arbitrate in our democratic and internal developmental process. The law is clear. When election has been concluded, you can challenge election on three main grounds. One, that the winner of the election does not is not elected by lawful majority votes, or that the election is invalidated by non-compliance with the Electoral Act or corrupt practices, or as at the time of the election, the winner of the election is not qualified to contest. And when such dispute has been submitted, then it remains for the court to look into the matter. And some of the issues that are even being raised are matters that are extraneous to law. To talk about unlawful, somebody not winning lawful majority vote, you need to demonstrate that you are claiming the person is not lawfully elected is having the lawful majority. But how do you demonstrate that? By relying on fiction. Somebody who came third, for instance, is saying is the one that ought to be declared as lawful majority. Why would that person put Atiku Abubakar, who came second, in the contest? When even the second person who claimed that he won the election is saying in the same breath that the election is invalidated by non-compliance and corrupt practices. Can you be seeking to declare a winner in an election that you have said is fraught with corrupt practices, to the extent that even said materials were produced by certain contractors, there were no reverse logistics, and so on and so forth? So we should not scandalize Nigerian judiciary. We should not seek to intimidate the Nigerian judiciary from coming to a rightful interpretation of the fact and the law as to what happened in the 2023 general election. Then when you also begin to put interpretation that are not purposive, that are not even expected from legal practitioners and being bandied by legal practitioner and non-legal practitioner. And in this context, the so-called dispute as to controversy as to 25% requirement in the Federal Capital Territory. My own immediate reaction would be that maybe people who are in Federal Capital Territory are superhuman beings and they were produced by eggs and sperms that are extraordinary, that their own 25% will be what will confer legitimacy on an election in the presidential contest. I'm not oblivious of the fact that the Supreme Court has said that when you are interpreting Constitution, you must look at what is called purposive approach to interpretation of the Constitution. And one of the earliest authority in this regard is the case of PDP and INEC in 1999. When Alhaji Atiku Abubakar was elected as governor, the deputy governor, Boni Haruna, stepped into his shoe. At that time, the constitutional decree stated that will happen in the case of the death of the person elected as the governor. And the Supreme Court said death in that regard will not be taken in the literal context. It has to be taken in the context of purpose and intent of the framer of the Constitution. And they said that unavailability, disappearance, will also fit the meaning of death in the context of that law. And now you are talking about and FCT in the legislation, and people are banditing around and said until the person secure 25% majority in the Federal Capital Territory, such a person, even having secure majority in the national election, also secure 1/4 in other states of the federation, will not be declared a winner. And I don't think any court of law will allow himself to be dragged into the absurdity. Then you also see an attempt to even unnecessarily scandalize and create red herring where there's none. And that is on the issue of the so-called qualification of the vice presidential candidate of the APC. It has been alleged that as at the time he was nominated as vice presidential candidate of the party, he was a nominated candidate for the Borno Central Senatorial seat. The provision of Section 35 of Electoral Act is clear. It's talking about constituency, not office. The presidential election is as to office and not to constituency. So you cannot interpose provisions talking about double nomination in constituency in the context of an office, which is different from a constituency. I think those are part of the issues that we need to really digest the Electoral Act address our mind to the salient provisions before people come, with different kind of permutations, seeking to unnecessarily eat up the polity and seeking to undermine, the judiciary, who I believe is well seized of the law and the fact and be able to do justice in that regard.
You know, this whole business about people shouldn't, I've read the commentary in papers, people should desist from intimidating the judiciary. I wonder, Senator, to what extent can anybody do that? I mean, people can talk. Talk is cheap. I imagine that the lordships, in the judiciary, in the Supreme Court or wherever, they don't probably get their own briefs or understanding of issues from opinions flying up and down in newspapers. You refer to Chimamanda Adichie. Yeah, she's a talented writer, indeed world-known writer, but she's not part of it.
She's not learned, if I may use that word.
She's not learned, even though she's an excellent writer, and has been honored for her skill. But
she's not learned.
So she was expressing her opinion. Unfortunately, it was to a foreign president. And she's expressing her opinion and asking for assistance, if I understand it right, of a foreign president. Well, this is election season, so I don't. Do you see our judicial system taking any cognizance of all of that way she's decided is an all right way to express her opinion?
Yeah, it's not. I'm not particularly talking about what Chimamanda wrote. As a writer, she's free to write. And of course, the way I see her writing is also an extension of fictional writing that she has been used to, and she's well talented at that. There's a difference between stating law and fact and applying that law and fact to practical reality and writing fiction. So for me, the piece she has written is an excellent piece of fictional writing coming from our imagination rather than reality. But what I'm saying here is this, and you will see the genesis of what I'm trying to say. Some person posted a picture of the CJN on the there, and then a story came that the CJN had gone to go and meet Ajibola Tinubu clandestinely in London, and of course, the fact actually showed that at that particular point in time, Ajibola Tinubu was not in London, he was rather in France. So you see a situation whereby polity is being heated up so that eventually, when these petitions eventually got dismissed, as I believe they will be dismissed, because looking at the Electoral Act and the fact alleged they are not sustainable, it will now be as if creating in the mind of an average, honest Nigerian, as if it is a result of any untoward activity.
Interference.
And also, you also now see this one followed up by the open confrontation and the outburst by Dati Ahmed, who is even in a position not to say that if he's alive to his own personal trajectory in the political space. This was a person purportedly elected into the Senate, and his election was subsequently nullified after sitting for 6 months in the Allo chamber, now calling that the president-elect ought not to have been sworn in because they have filed some form of a petition. So what was he doing in the Senate chamber when his election was being challenged, when he was purportedly elected on the platform of the CPC? I think when people raise the bar of morality, they should also be able to judge themselves by that bar of morality that they expect another to do so. The position of the law as it is today, yes, judges are bound by the pleadings of the party, by the evidence adduced by the party, and of course by the law applicable to that. But in the sociological context, we must be able to insulate our judiciary for unnecessary harassment and possible imputation of improper motive when such are not based on fact and they are not based on reality. And they are just suggestive to prepare a case for, with respect, if I may use the word, some of their gullible followers who would think that they have a case. Because how will you begin to talk of somebody who came third in an election talking about stolen mandate. So who stole whose mandate? Is it so two set of candidates stole the mandate of the person who was third in a race, or what? So what we are saying as a legal practitioner, the building, one of the building blocks of democracy is rule of law. One of the building blocks of that rule of law is independence and integrity of the judiciary. We cannot, on the altar of political expediency, allow our judges to be attacked, even though they cannot defend themselves. We must rise to the occasion to say, for those of you who have filed petition, go to the tribunal, rein in your supporters. Let them go and conduct, their battles, before the court, and stop all these frivolous allegations against men and women who have dedicated to their life to the cause of serving the judicial sector in our country.
Okay.